Well, good morning, everyone. This is Steve Holden from the Holden Law Group. I am going to be your presenter today on this webinar. We're going to wait for just a minute or two to give everybody the opportunity to get logged on. Hopefully nobody had any issues with that. So hang in there tight, and we'll get started in just a few minutes. Well, good morning again. This is Steve Holden with the Holden Law Group. Welcome to everybody, and looking forward to giving you some information about independent contractors. I can't recall exactly how Melissa titled this webinar for y'all, but as you can see on our opening screen, I'm calling it Using Independent Contractors, Dynamex, and AB5, because Dynamex, a court decision, and AB5, a new law, dramatically change independent contractor law in California. So we wanted to give y'all the information you need to decide what to do on that. So we will be recording this webinar, and Melissa wanted me to let you all know that she will be sending a copy of the recording and slides if you want them to you, so that you have a record of what was presented today. At the end of the content, we will also do Q&A, and on your screen you should have a place where you can type in your questions, and we welcome you to do that throughout the webinar. I will say there's a large number of people who signed up for this particular webinar, and the questions that I'll focus on at the end would be those questions that are clarifications about what was discussed in the presentation, or questions generally about the new laws and independent contractors and independent contractor law, as opposed to those questions that are very fact specific to your organization. We're of course happy to address those questions, and those are oftentimes the burning questions for you, but that is difficult to do in a large group setting like this, because it takes a lot of time to get immersed in the facts and then provide guidance on those facts. So if you think about the questions that you have, you can type any question, and we will try to get to as many as possible, but I'm going to focus first on those that are more generalized and not about specific facts about your organization. There's probably 6 or 7 other things I'm supposed to tell you as a lead in to this webinar, but I'm lame and I don't know what they are. So let's just get started. Here's the game plan for today. I'm going to try and cover for you background and history on ICEE law. ICEE means independent contractor versus employee, and the laws that impact whether somebody is properly classified as an independent contractor. I'm also going to review the Dynamex decision, which is a California Supreme Court case that was decided at the end of April of 2018, very significant case, which led into AB5, legislation that was passed this year that will take effect January 1, 2020, that significantly changes independent contractor law in California. We'll talk about why it really matters, and I'll give you an example of why it really matters or should matter, and recommendations, and then we'll roll into Q&A. So again, if you have questions, feel free to type them in there, and I'll address as many as possible. If we don't get to them all, of course, you know where to reach us, and we will try to make sure you get all the information you need leading into 2020. So I want to start by setting the stage for this whole thing. And I realize that the very best way to set the stage for this whole thing is to read you the introductory paragraphs from the Dynamex decision from the California Supreme Court, because they did a really good job of setting the stage for what does this all mean, independent contractor employee. So typically I wouldn't just read to you during a webinar or any other presentation, but in this particular case I'm going to read verbatim the introductory paragraphs from the Dynamex decision. Under both California and federal law, the question of whether an individual worker should properly be classified as an employee or instead an independent contractor has considerable significance for workers, businesses, and the public generally. On the one hand, if a worker should properly be classified as an employee, the hiring business bears the responsibility of paying federal Social Security and payroll taxes, unemployment insurance taxes, state employment taxes, and providing workers' compensation insurance and complying with numerous state and federal statutes and regulations governing the wages, hours, and working conditions of employees. The worker then obtains the protection of the applicable labor laws and regulations. On the other hand, if a worker should properly be classified as an independent contractor, the business does not bear any of those costs or responsibilities. The worker obtains none of the numerous labor law benefits, and the public may be required under applicable laws to assume additional financial burdens with respect to such workers and their families. Although in some circumstances, classification as an independent contractor may be advantageous to workers as well as to businesses, the risk that workers who should be treated as employees may be improperly misclassified as independent contractors is significant in light of the potential substantial economic incentives that a business may have in mischaracterizing some workers as independent contractors. Such incentives include the unfair competitive advantage that a business may obtain over competitors that properly classify similar workers as employees, and that thereby assume the fiscal and other responsibilities and burdens that an employer owes to its employees. In recent years, the relevant regulatory agencies of both federal and state governments have declared that the misclassification of workers as independent contractors rather than employees is a very serious problem, depriving federal and state governments of billions of dollars in tax revenue and millions of workers of the labor law protections to which they are entitled. So that gives you the stage or the backdrop for all of this. And that last paragraph in particular clearly evidences the reason that government is involved in the independent contractor versus employee relationship in a deep, deep way. And there are two reasons why the government agencies have always been adverse to a classification as an independent contractor. As noted by the Supreme Court in what I read, it's billions of dollars in tax revenue that they don't get for independent contractors. And there's another reason. The agencies that we deal with that touch the employment relationship, like EDD, the DFEH, the EEOC, the Department of Labor, all of those agencies have a tendency or a pre-wiring to feel like they have to protect workers, a paternalistic view that they are the backstop and protector of workers. So it's that protective paternalistic view of government that if they didn't protect workers, employers would take advantage. And the missing tax dollars that have driven the government to be very adverse to independent contractor relationships and looking to attack them and instead treat the worker as an employee. So that's the backdrop, that's the stage for all of this. It's not new. The struggle for an answer on whether somebody's an independent contractor or an employee has gone on for decades and decades and decades. Initially, the test for determining whether somebody was truly an independent contractor was, as you can see on the slide, called the control of details test. That's what we label it now. And it arose in tort, in personal injury. And it came about this way, that if I hired somebody to do a work for me and I controlled them to a significant degree, and then they went out and they injured somebody, some third party, well, I shouldn't be able to escape the liability to that third party for the injury by saying, hey, that worker is not my employee, it's an independent contractor. And so control of details was the first test and for determining whether somebody was an independent contractor or employee. But as decades progressed through the beginning and middle of the last century, we added social welfare legislation, things like workers' compensation coverage for employees, things like unemployment insurance protection for employees. And because that social welfare legislation was in place to protect employees, but wasn't providing any protection for a worker who was labeled as an independent contractor, courts saw that as, I won't say unfair, but what they saw it as that the legislation and the intention of government through passing those laws for workers' comp, unemployment insurance, etc., wasn't being furthered by using just the control of details test because it was too easy to get past that and have the label be an independent contractor. So the courts began to add secondary factors to the test when they reviewed cases about independent contractor versus employee. And that continued into what we then called an economic realities test. And these multi-factor tests where you would look at a whole variety, or a court would look at a whole variety of factors to determine whether or not a person was an independent contractor legitimately or an employee. And then the economic realities test looked at all of those factors, but then it was sort of this step back and look at it as a whole. And does it look more like employment, or does it look more like an independent business that I'm doing business with? Out of all that, there was a case in the California Supreme Court called S.G. Borrello and Sons in 1989. And that set the stage for the primary multi-factor test or analysis in California for many of the employment related regulations and laws. So, for instance, whether or not somebody is an employee or an independent contractor for purposes of workers' compensation and the requirement to have workers' compensation insurance was decided by the Borrello standard. And Borrello was a case of a farmer in the Central Valley who planted and harvested and sold cucumbers and other crops. But what they did is they rather ingeniously carved out the actual harvesting of the cucumbers and developed what they called self-employed share farmer agreements with the workers who are actually harvesting the cucumbers. And they went, I won't go into all the details, but whoever put it together was fairly sophisticated in how they were setting up the agreements with these farm workers and determining who had responsibilities for the various factors. But at the end of the day, the California Supreme Court looked at that and said, no, the farmer still was in control really of the whole operation. And what they were trying to do was just carve out a single integrated step in the whole process of planting, raising, harvesting, and selling cucumbers. And they were not going to let the farmer treat those workers who were just doing the harvesting part of it as independent contractors. So out of that case, we got the factors that you look at in the analysis for the general independent contractor versus employees. Since then and before then, there were a number of hybrids. And I say hybrids is because what happens is when there's an actual case and a court is making a decision on whether somebody's employee or independent contractor, they're going to look at multi-factors, but they don't look at them all necessarily. They may look at 5, 6, 7, 8, 10, those that are most relevant to the facts that they're dealing with. And so if you go look at the hundreds and thousands of cases, not hundreds of thousands, but hundreds, or there's probably thousands of cases dealing with independent contractors, both federal law, state law, you will see that the courts use all multi-factor tests, but they're not all virtually identical. Well, then we got Dynamex in, as I said, April 30th of 2018. And we'll talk about Dynamex in a minute in detail, but then Dynamex led into the legislation that was passed in October and will take effect in January, AB 5, which broadens Dynamex beyond the court decision itself to the many of the employment-related laws and regulations. So that's the background. Here's a screen with some of what you would see as the factors in a multi-factor test, like the Borello test. Now, if you count these bullet points, I only have 12 on here. There are many more than that are used by the court. So, for instance, one of the first labeled multi-factor tests was the 20-factor test used by the IRS to determine whether or not somebody was an independent contractor or employee. At one point in time years ago, EDD had a 24-factor test. So you will see different numbers of factors depending on where you look for tests. I could only fit 12 on the screen here, so this is the Steve's 12-factor test. I put 12 up here just to give you an idea of the things that you would be looking at, or a court would be looking at, under a multi-factor test to determine whether or not somebody is legitimately an independent contractor. Okay, it's back to that sort of economic reality. These are all the things that if there's no supervision and training, if it's a highly skilled position, if it's a not a very permanent relationship, but just come in, do a job, and get out, if there's no ability to discharge at will, if the work that the worker is doing is not an integral part of the hiring business's normal processes or business, et cetera, et cetera. Those factors then are all going to make it look more like an independent contractor, or vice versa. Again, under the multi-factor test, no one factor controls. You're going to look at all of them in the context of the facts you're dealing with, and then a court or a government agency is going to decide, does it look more like employment, or does it look more like legitimate independent contractor? So that's an example of the factors that you'd look at in a multi-factor test like Borello. But then we get to Dynamex, and as you can see on the slide, the case in Dynamex was filed in the Superior Court in April of 2005. We got this California Supreme Court's decision on April 30th, 2018. 13 years of litigation going up and down between the appellate court and the Superior Court to trial court before ultimately getting to the Supreme Court. And the reason I put that in there is a reminder. Later we're going to talk about why all this matters. But if you get embroiled in litigation and you are thinking, well, I'm going to prove that we have a legitimate independent contractor relationship, and I'm going to take this to the end, one of the things you're bargaining for is 13 years worth of litigation and attorney's fees. So it's pretty rare that an organization can afford to do that. And then also, the reason I stuck that in here is many of you at the end of this webinar and beyond are still going to be asking yourself the question, geez, what are we going to do? How are we going to deal with all of this? And it's a difficult thing because law develops very slowly. In your organizations and businesses, things happen very rapidly, and you have to react very rapidly. And unfortunately, the law drags on way behind business realities. And so oftentimes there aren't definitive decisions legally that can guide you as a business. You have to decide your best guess at how things are going to go and the risks that you're going to take. And we'll talk about that a little bit more in the end. But getting back to Dynamex, it was a class action lawsuit. Dynamex is a company, nationwide company, that provided same-day delivery service of package and documents. And the issue was that plaintiff's attorney had filed this class action alleging that the drivers should have been classified as employees as opposed to independent contractors, and therefore been paid for overtime, given meal and rest breaks, given pay stubs, on and on and on, with all of the labor law requirements for an employee that were not done because the Dynamex company had labeled these folks as independent contractors. And the key in the case was that the definition of what it means to employ under the California wage orders had surprisingly never been litigated to the Supreme Court. What it means to employ under workers' compensation law had, the Borello case. In other contexts, that had been litigated and decided, but the test for deciding what it means to be employed under the wage orders had not. So that's what the California Supreme Court was charged with doing is, well, what does it mean under the wage order to employ, and therefore what's the difference between an employee and an independent contractor? Well, Dynamex was fairly dead on arrival from my opinion, but obviously they didn't mind paying lawyers. And I say dead on arrival because prior to 2004, the company had treated the drivers as employees. They classified them as employees, followed all the rules as employees. But in 2004, the executives of the company got together and decided that they were going to convert the employees to an independent contractor model because conversion, I'm quoting now from the court's decision, because conversion would generate economic savings for the company. So there was evidence in the case that they converted employees to independent contractors for economic advantage of the company. You will never be able to convert an employee to an independent contractor and have any level of surety that you're going to be successful in doing it. That is a major red flag. Notwithstanding that, if you went through the analysis in Dynamex of how much independence the drivers had, how much control Dynamex had, there were pluses and minuses. The drivers had to at times wear uniforms, but they could set their own hours. They could reject deliveries if they wanted to. They had to provide their own vehicles. They had to provide the maintenance on their vehicles. So there were pluses and minuses that went both ways that could be argued. But ultimately, the court determined that they were in fact employees. But doing it, and the significance is that because there wasn't a definition previously for what it means to employ under the wage orders, and I say a definition or a specific test for what it means to employ, the California Supreme Court, adopted an entirely new test that never existed in California before. They looked to jurisdictions outside of California, and they adopted what's called the ABC test that had never existed in California before. And so it was a dramatic decision for sure. So let's go through what the ABC test is. First, for a worker to be properly classified as an independent contractor, the hiring entity bears the burden of establishing three factors. Now, I only put up that first part of it because I want to definitely highlight for you that out of Dynamex and what the law is today, if you're the hiring entity, you bear the burden of proving that you have properly classified the worker. Even though you're going to be the defendant in the case, you bear the burden of proof on the issue of independent contractor versus employee. And that is typically in a lawsuit, if you're the defendant, you do not bear the burden of proof. The plaintiff does. But in this context, you bear the burden of proving it. That heightens the danger of getting it wrong and making a misclassification. So again, I want to highlight that there is a presumption that if you engage a worker, that worker is your employee, and you have to overcome that presumption in the law because you bear the burden of proof. Okay, so the first factor for ABC test is that the worker is free of control, and that means free of control under the agreement or the contract that you have, but also free of control as a matter of fact. So on paper, they're free of control, but they also, as you go through the actual relationship, that's the way it needs to be in practice. Okay, well, that A factor, that's just what we've already had in terms of the multi-factor tests, Borello, etc. Okay, that's a primary thing that's already existed. That's not new. I'm going to jump over the B factor and go to the C factor. The C factor is that the worker is customarily engaged in an independently established trade or business, and the work they're doing is that independently established trade or business. So, for instance, they are in the plumbing business, and the work they're doing is plumbing. Okay. Also, the C factor is one that already existed in the multi-factor test, not new. What is new is the B factor. Okay, that the worker is performing work that is outside the usual course of the hiring entity's business. Now, that actually was a factor, and you'll see it in the multi-factor tests. However, it was only a factor. Under the ABC test, if you're going to label somebody and classify them as an independent contractor, you must be able to prove all three of these factors. Okay? It's not just weighing them, you've got to prove them all. And for the great majority of people who are using independent contractors in the normal operations of their business, the B factor trips them up because you can't show that it's not a part of the usual course of your business or your organization. So I always use as an example the law firm. If we have a leak in one of the bathrooms in the sink and we call a plumber and the plumber comes out and fixes the sink, I'm going to be fine on the B factor because plumbing and fixing sinks is not the usual course of the law firm or HR consulting services. But if I start to get at for instance, if I engaged somebody to provide some of the services that we provide to clients, that's usual course of the firm's business, and we would not be able to pass the B factor. Okay, so that's the ABC test. The ABC test. Now, I got myself confused there because I flipped to a slide that says AB. AB meaning Assembly Bill 5. Fast forward to this October, and what the California legislature did was say, hey, we like Dynamex. We like the fact that by applying the ABC test, we are going to have fewer independent contractors and more employees. And so we're going to broaden the Dynamex decision, which only applied to wage orders, and we're going to broaden it to apply to all labor code claims, the wage orders, which Dynamex already did, to workers' compensation law, and to unemployment insurance. Okay. Now, if you're talking about discrimination harassment law, we still would be using the Borello test. But for labor code claims, workers' comp and employment, you're going to be now using the ABC test according to the new statute. And it's also made clear that the law is retroactive with regard to labor code claims and wage and hour claims. In other words, if you had somebody misclassified and you treated them as an independent contractor in 2017, but they really should have been an employee, that person would be able to bring claims based upon how you classified them in 2017, even though this is a new statute. Because essentially what the legislature said is the law is not new. This is what it should have been in 2017. We're just reaffirming that that's what it should be. Okay. Now, with respect to unemployment insurance, then it's going to be a prospective and it will take effect in January of 2020. The same with workers' comp. Now, there are some exceptions to AB5 and the application of the ABC test across the board. Accepted from or carved out of AB5 are specified licensed white-collar professions where there are licenses involved. So doctors, lawyers, CPAs, maybe some engineers. If you're in the white collar, if you're classifying a worker who's a white-collar professional who's licensed, we'd want to look at the actual text of AB5 and see if your particular worker falls within those that are accepted. Okay? There's an exception for what's called professional services. Now that sounds like that could be pretty broad. There's a lot of professional services, and you might even be saying, hey, what we do is professional services, and this person that we're engaging does professional services, therefore they must be exempt from the ABC test under the new law. Not so, because professional services, and you can't see it now, but I'm doing air quotes, is defined specifically under the new law, and it's pretty narrow, and I've put on the slide those specific types of work that are included. So if you fall within any of those, again, a little further depth of looking into the statute, which is pages and pages long, mind you, to make sure that you actually, the graphic design work that you're engaging would fall under professional services, okay? Then under the law, there's another exception for what's called business-to-business contracting relationships. And when you first look at that, you say, oh, aha, this is it. I have the business-to-business contracting relationship with this contractor that we've been working with now for years, and that's what it is. It's a business-to-business contracting relationship. I'm good. Unfortunately, that's not going to be the case for so many of you, because what it means to be a business-to-business contracting relationship has an extremely long definition and multi-factors that must be met that are all delineated in the statute. And the biggest problem of meeting all those delineated factors is the bullet point that I've put on the slide here. The worker or the person providing services cannot provide those services to the clients or customers of the engaging entity, but rather must provide those services to the engaging entity. So in effect, it looks like, and would, as a practical matter, be very similar to the B factor under the ABC test. And for that reason, the business-to-business contracting relationship may not be the panacea for many of you in terms of saving relationships that you have as legitimate independent contractor relationships. Also under the business-to-business contracting relationship definition, which again is very long and lengthy, it specifies that it doesn't apply to an individual worker as opposed to a business entity. So if you're dealing with somebody who's, I'll use as an example one that I've discussed with a number of clients, and that is owner-operators in the transportation business, somebody who owns and operates their own big rig truck. That the business-to-business relationship's not going to work there because of the subsection of the law that says it doesn't apply to an individual as opposed to a business entity. So the next exception would be in the construction industry for the traditional relationships that we've had between contractors and licensed subcontractors. And so in that arena, the ABC test, it does not apply. Also, there's an exception for construction trucking services, but that is one that is limited to essentially a year, and then it will go away. And there is an exception for referral agencies, and I don't know if we have anybody on the webinar who's a referral agency, but it's pretty limited and very specific services that meet the definition of what a referral agency is. But if you think you're a referral agency, we could look into to whether it applies. An example of where it doesn't apply or would not likely apply is in transportation, the brokering of logistics, for instance, because it's the specific services listed in the statute do not include the brokering of logistic services or trucking. So those are the exceptions, and as I pointed out, they are pretty limited. Now, if you fall under one of these exceptions, I'll just take construction, for instance. You're a general contractor, and so your relationship with your licensed subcontractors remains an independent contractor relationship. The ABC test does not apply, but Borello still does. So you still have to make sure that those relationships that you have with subcontractors or independent contractors meet the multi-factor tests under Borello. But the ABC test and that B factor that the work has to be outside the usual course and scope of the hiring entity's business does not apply. So is anybody out there thinking, this is no big deal? Dynamex, AB5, few little changes to independent contractor, no big deal. I'm not hearing anybody who's saying that. Judging by the number of people who signed up for this webinar, judging by the number of times that we've been asked to write about it, to go speak to employer associations about it, etc., it's a huge deal for many. It's a monstrous deal in some industries where independent contractor models of doing business are at the foundation of the whole industry. And so how it's going to impact those, it will take time to see precisely. Certainly, there was a lot of lobbying that went on by industries before AB5 was passed. Some of it successful. So, for instance, manicurists and barbers have an exception, but others didn't make it. So, a broad exception in the transportation industry for drivers, it didn't happen. A limited exception in construction for a year. So we'll probably see more lobbying going on, and there's the possibility that there will be more carve-outs based upon that lobbying activity from AB5, but you're still going to have to deal with the multi-factor tests of Borello. But it is a big deal, and the reason why it is a big deal, not only for those that are going to have to sort of change the way you do business, but even for those that don't, if you misclassify a worker as an independent contractor as opposed to an employee, by definition, you're not going to be complying with any of the labor laws. So you have exposure to all of them. Because if somebody is properly classified as an independent contractor, you're not going to be tracking their time. You're not going to be paying them with payroll and pay stubs. You're not going to be paying overtime. You're not going to be watching to see that they get meal and rest breaks. You're not going to be providing workers' comp. You go on and on. By definition, you won't do anything that you should be doing if they're an employee. So that means the misclassification decision is huge because by definition, it means you won't be complying with any of the laws. So I wanted to give you a really quick example that I put together in literally about 10 minutes to show you why it's significant. And what I did was I hypothetically took a worker that was paid $25 an hour who worked on average 9 hours a day during a 5-day work week so that they had 5 hours of overtime each week and went back for 3 years, which is the statute of limitations for most wage and hour stuff. And I just threw in the most obvious and the simplest of violations and the penalties that go with them. And for this one employee paid $25 who on average worked 9 hours a day on a 5-day work week, the exposure at a minimum, because there's many other statutes and penalties that I didn't dig into here to put this quick example together, would be over $200,000, not including the fact that you are also going to have to pay their attorney's fees and court costs. That's one employee. Now think of a class action and you have 100 employees. You can see why all of a sudden it makes a big difference because of the stacking of penalties, particularly in wage and hour law. So what are you going to do? The recommendations I have is step one, stop in your tracks and very carefully analyze any contractor relationship that currently exists in your operations, down to the level of hiring the plumber to come fix the sink. Now, the plumber fixing the sink, you're good, more than likely, if it's a licensed plumber who has an actual business that markets and has a truck and all the rest of it. Okay, but you may have relationships that you've gone on for years that you really haven't carefully analyzed. Now's the time to do that for sure. Step number two, for many of you, you're going to have to consider structural or operational changes, changing the way you do business if you're going to continue to want to use independent contractors, or changing the way that you do business because those workers can no longer safely be considered independent contractors and will have to be converted to employees. Okay? If you're going to maintain a contracting relationship, an independent contractor relationship, you must have a well-written agreement that accounts for that relationship, is taking into consideration the factors that a court would be looking at, and in particular, the B factor of ABC if it applies to you. And then you're going to want to make sure that you're living according to that agreement. Both you and the contractor actually having a relationship that is consistent with that agreement. And that's what I mean by monitor and work according to the agreement. I don't mean monitor the work of the independent contractor, because that would make it look more like employment. I mean monitor that what is actually happening day to day in the relationship is consistent with that agreement. And if you can't come up with a legitimate independent contracting relationship, then you're going to be forced to take some workers and convert them to employment. Well, obviously, if you're going to do that, the recommendation is develop a strategic communication plan, because you wouldn't want to go in and say, okay, well, we're going to have an all-team meeting today, and oh, guess what? We have been misclassifying you guys for years now, and that's been pointed out to us by the California legislature, so we're going to convert you all now to employees. Because remember, you've got exposure in those past years because AB5 and Dynamex are retroactive. In essence, they're saying this was always the law, we just never told you. So there's exposure for those back years for certain types of claims. And so you want to be strategic in communicating this so that you're not raising red flags that you don't need to raise. And when I say strategic, oftentimes what we're looking for is, well, what other things are going on in your organization? And how can we combine changing classifications of workers with that so that it isn't quite as obvious and doesn't raise as many red flags. And obviously, there's other choices. I mean, depending upon the size of the organization, the number of people, and the risk that you face, the probability that somebody might make a claim, and the cost of that, there might be other strategic steps you could take in terms of reaching agreements with workers who are classified as independent contractors, etc. That just gets a little more sophisticated, but also very fact specific to the people that you've been using in your operations. So that's it. Now I'm going to dig into seeing if I can get some of your questions answered. So I'm rolling over here to the Q&A section. So somebody asked, does Dynamex trump the Borello law? Meaning, is Borello out and Dynamex in? No, that is not the case. It does with respect to certain types of claims and law. So Dynamex and AB5 is going to trump Borello as far as wage claims, as far as the wage orders, the unemployment insurance law, workers' comp law, but it does not for those exceptions to AB5, like white-collar professionals. Borello still applies. Borello still applies in discrimination, harassment law, and other aspects of employment. Safety is another example where Borello or a Borello-like standard would apply. Can licensed counseling therapists be considered independent contractors? Excellent question. I don't know. I would literally have to pull AB5 and look at that list of licensed professionals and the lengthy description of who gets to come under the white collar exception to answer that question. But reference to the statute itself, we could probably get a pretty quick answer on that one. How do IT consultants factor into professional services? My recollection is IT was not one of the enumerated types of, and I'm doing air quotes again, professional services. It was marketing, HR consulting, some design services, but again, that would require getting more information about what you mean as an IT consultant and going back to the statute and seeing if it fit within the definition there for professional services. Will the slides be available? Yes, they will. My understanding is Melissa will be sending them out to you along with the recording. If for some reason you don't get them, just let us know, and we will certainly make sure you can have them. Here's a good question. I'm trying to maybe figure out a way to paraphrase this a little bit. The question is, would you address the application of the B factor to business support functions, such as using a contractor for IT services for a business? I think that's a perfect example of what I'll call a wobbler or a close to the line situation. Because certainly you could say, well, having technology is an important part of an organization's business, but does that meet the definition of the usual course of the employer's business? And frankly, I can't tell you for sure. I think that will be something that will certainly be litigated over time as what does it mean to be the usual course of the hiring entity's business. My guess is that back office business support functions like IT will ultimately be ruled by courts to not be part of a entity's usual course of business, and that they'll focus more on what is the business do what services do they deliver, and if what's being engaged is an integral part of that or the production function, as we would discuss in exemption law, that's where the B factor is going to be. But I can't tell you that for sure. And certainly looking at IT support services or other business services it could be an issue for sure. But you probably are going to get relief there from the business to business exception under the statute. Because again, the IT support company will be providing services directly to you to keep your computers and technology running and not delivering those services out to your customers. I hope that helps. Question. The question is, how does this affect if we use a temporary employment service? Well, it could, depending upon whether or not we're talking about a referral agency. We might have some application of that aspect of AB5. But if you're talking about we get workers who come to us through a temp agency, their payroll, their workers' comp, taxes, that's all paid for by the temp company who sends them to us, and then they just work in our environment under our control. Ultimately, what's going to delineate whether or not they're your employee is what's called the joint employer law. So a little bit separate law from what we're talking about. But through joint employer, if that temporary service agency that you're getting the workers from fail to properly classify the workers, and for instance are not paying payroll taxes or not paying wages correctly, etc., that liability could shift over to you, and in many instances fairly easily, through what's called a joint employer liability theory. So it's a little bit different, but the exposure certainly doesn't go away just because you are hiring somebody. I shouldn't say hire somebody. You're engaging somebody to work through a temporary service agency. Sorry for the delay. I'm trying to go through these many questions and pick ones that are going to be most applicable to everybody generally. Yeah, a lot of these questions are very specific to individual facts, and to which many of which I would need a lot more facts in order to answer these questions. So for those of you, I apologize for that. We would just have to dig in with more background facts in order to get you an answer. I'm continuing to just look for those where we have more general application. Oh, there's a question in here about what about interstate commerce? And if you're in transportation, and it looks like a number of you are in transportation, there's that whole issue of, well, wait a minute, what about federal preemption and federal law essentially trumping California's laws and California's new laws? Well, that is going to apply itself in a slightly different way. So federal law is not going to likely preempt AB5 and the test for independent contractor relationship in California for purposes of California laws and regulations. That's highly unlikely that when AB5 is challenged or there are court cases, that what we're going to find is federal law saying, no, wait a minute, federal law trumps state law in this. But the interstate commerce is going to come in a different way. If you're engaged in interstate commerce, you might, and you're in the transportation industry, you might have an exception to many or some of the California wage or laws that have been such a hot topic for class actions because the specific rules within California wage and hour law are preempted by rules that exist under federal transportation law. So it might be that you'd still have somebody who's considered a worker because you lose under the B factor of the ABC test, but you don't have liability, for instance, for meal and rest periods because federal law trumps the state meal and rest period law. I hope that wasn't too confusing, but that's how the interstate commerce piece of it fits in. Okay, I'm going to go see if there's anything else in here. Again, these are really fact specific questions. So with that, I am going to close the seminar. Thank everybody for participating. I know that there are a number of you who have questions here that didn't get answered through this webinar, but again, they're very fact specific, and in some instances your question doesn't have enough facts for me to answer it. So if you want to, you certainly can pass those on, and we'll do our very best to get those specific questions answered for you. And again, we thank you for joining us this morning and hope you have a great rest of the week.